SJC-10505, Commonwealth versus Pierre Cadet.
Mr. Doyle, good morning.
Good morning. May it please the court, this is a first-degree murder case which went to the jury on theories of extreme atrocity and cruelty and deliberate premeditation. The jury returned a verdict of guilty on the question of extreme atrocity and cruelty, but did not return a verdict on the question of deliberate premeditation. After our brief was filed in this case on the issue of public trial, this court decided the case of Commonwealth versus LaChance. We acknowledge, to begin with, that we can show no particular result influencing prejudice from this. However, because this case is on direct appeal, has not been decided, because the finality considerations which motivated members of the majority in the LaChance case do not bear on this case in the same way, we believe that's still a live issue. We would nevertheless not abandon that claim if we did not think that that was true in terms of this court's jurisprudence. The problem that arises for us in terms of the public trial claim is the findings of the trial judge on the new trial motion. And I'd like to spend a couple of moments, if I could, focusing on the way the trial judge determined that there was not sufficient evidence that the defendant had requested a public trial or that, in fact, the courtroom was closed. As to each of those areas, the trial judge was making factual findings regarding matters which he could not have had personal knowledge of. He could not have been at the counsel table. He could not have been in the hallway. And as to each of those matters, he attempts to fill those gaps with methods that we argue are improper and deny the defendant of due process in terms of the fact-finding.
Didn't trial counsel not testify at the public trial?
Trial counsel did not testify at the trial.
And the trial judge discredited the witnesses who did testify?
Yes, and that's one of the points we'd like to address. What the trial judge did was essentially draw a missing witness inference from the failure of trial counsel to testify at the new trial hearing. In our view, this is not a good missing witness moment. Trial counsel in an ineffective assistance counsel case is available to the Commonwealth to call as a witness should the Commonwealth so choose, although the Commonwealth does have to seek judicial authorization to get that.
But as a practical matter, I mean, that's a very tough place to be in, don't you think? I mean, for trial, I mean, it puts trial counsel in an impossible position.
Your Honor, trial counsel is often in impossible positions, and I'm afraid that it doesn't require, there's no logical connection between the difficulty of trial counsel's position and drawing an inference. The inference of an unfavorable inference from not calling trial counsel is, I think, on the same grounds as it would be to draw an inference against the Commonwealth because they did not call court officers to say that the courtroom was not closed. And this is not a case, I would point out, where the internal thinking of trial counsel's reasoning is implicated. The question here is, what did trial counsel do? What did trial counsel not do? That's clear on the record. What trial counsel did not do was object, and that's plain. If there was some excuse for his not objecting, that's for the Commonwealth, we argue, to raise, and that it's not something where an inference can be drawn when the witness is equally available to both parties. I agree, it may not be equally unpleasant for both parties, but that I don't think can be the legal standard.
The trial counsel would have been, if the trial judge disbelieved your client's testimony that he wanted his family there and instructed him to make it happen, basically.
Which is what the trial judge did do.
I'm sorry.
That is what the trial judge did, yes.
Yeah, disbelieved. So the trial attorney would be the only one then who could say whether or not that happened to the judge's satisfaction.
Yes, but our position is that the trial judge had no grounds for disbelieving the defendant's testimony. What the defendant was testifying to was nothing bizarre or
No, but a fact finder can always just sort of assess a witness and say, I think this person's not a truthful person. I mean, we always leave that in the trier of fact, with the trier of fact, don't we?
Yes, but not based simply on demeanor or not based simply on the fact that this happens to be the defendant in a criminal case.
No, not on, yes, but,
Which I believe, when you read the memorandum opinion in this case, will appear to you to be what happened here. On terms of the other issue, in terms of what happened outside in the hallway, it was not the case that this is simply a finding of failure to meet a burden of proof. The mechanism of decision when you have an opportunity to review the order is you say A, but I believe B, and you have not persuaded me that I am wrong about B. As to that mechanism, we believe that the court relied on a species of tacit judicial notice about what was happening out in the hallway, what usually happened, what often happened, what the court hoped was happening. But that's a very dangerous way to go about fact-finding.
Let's assume for argument that you're correct, that that the judge obviously didn't know what was happening in the courtroom, and so to the extent that your reading is correct, that he was making unfounded assumptions about what happened in the court outside the courtroom. In terms of his credibility findings, and also the fact that this is a motion on which your client has the burden of proof, does that really at the end of the day make a difference?
We argue that it does, Your Honor, because the findings that are crucial here are findings that are binary. The courtroom is either open or it's closed. Either the defendant asks for his family or the defendant doesn't ask for his family. It's not a question of, well, there's a spectrum of things here which could be true, and somewhere along the spectrum we believe some things but not others. In order to disbelieve one, the trial judge would have had to, and in fact I think the record indicates that this trial judge did believe something else. The basis for arriving at those things without evidence on the basis of first a missing witness instruction drawn from the absence of a witness who was available to both parties, and then...
Well, you say available to both parties, but I guess that's where my burden of proof question comes in. I mean... Well,
our burden is to prove that the defendant did ask.
Did ask, and that it was, I mean, for start, that it was ineffective assistance of counsel for trial counsel, assuming the asking for trial counsel not to have done something about it.
Yes, but we put on evidence that the defendant did ask. There is no evidence to say that the defendant did not ask, except an inference drawn, we argue, improperly from the absence of a witness. And so we would say that we would meet our burden of proof when we provide...
Just on the factual question, by doing
on that factual question, by bringing testimony, which is not contradicted, to bear on the issue.
Are you saying
in this situation, it would be as logical, possibly more, to draw a missing witness instruction against the Commonwealth for failing to call trial counsel to say, no, he never said that. But I'm not arguing in favor of that. I think it's an unreliable way to do fact-finding that violates due process.
I couldn't quite make out what you were suggesting would be the result of the fact that in our cases we've noted that in that particular session there were so many instances of it being closed during jury selection. Is that a fact that the judge should have taken account of?
Yes. And, of course, this court could take notice of its own opinions in terms of those matters.
And does that go to your burden in any way?
I believe that it shows that our burden, that the common practice there, which would have been known to anyone, if one were to resort to this kind of tacit judicial notice, would have fallen on that side. However, we also produced testimony from two witnesses, family members of the defendant.
Whom he disbelieved.
He disbelieved, but again, if we ask the court on reviewing the transcript of that hearing, if he disbelieves them simply on the inconsistencies that he's discussing, because they're inconsistent internally.
Yeah, but I just, I'm just troubled that, I think what you're saying is that a judge can't disbelieve somebody just on the basis that they don't seem truthful to him or her. And I think that that would be contrary to our jurisprudence, where we've always said that the trier of fact has the ability to assess someone's credibility. And I don't think you have to have something on the record that shows inconsistency or anything. You could just see, well, I don't know. I mean, I don't know if we've discussed this in our case law, but it seems to me a credibility assessment does have to do with demeanor.
Well, we do have on the record the judge's opinion in which he says part of his credibility calculus is what we say was improper, which is drawing a missing witness inference.
Yeah.
And so whatever the end result of the process, the judge has told us that he used as part of that process the missing witness mechanism, which we say is no better for that inference than it would be if I said, well, the Commonwealth didn't call any court officers to say this wasn't closed, therefore there's an inference that it was.
Decisive, the point that you're making, I mean, you said at the beginning that the courtroom was either opened or closed, and if the judge doesn't believe the witnesses who say that it was closed, that kind of defeats your argument, doesn't it? If you don't prove otherwise, because the client's, the defendant's request to counsel doesn't go to whether it was open or closed. That's a different issue.
There are two separate issues, each of which we feel the fact finding was faulty on. First is the request. The second is the closure of the courtroom.
Right.
As to the closure of the courtroom, 2 witnesses were called. They were not contradicted.
Well, one of them had lied at the grand jury about, I guess it was the defendant's brother, so the judge had good reason not to believe him, right?
Well, it's not, I think, feasible to go through and read the whole hearing transcript aloud to the court this morning, but I believe when the court reviews the transcript of that hearing, you will see that the credibility determination involving those 2 witnesses includes things that the judge regards as inconsistent that in fact are the ordinary lapses of lay witnesses trying to describe things that happened over a 2-day period.
But isn't this a matter of be careful what you wish for? In suppression motions, every day police officers testify. Their testimony is not contradicted. The defendant doesn't come to the stand and say that's not what happened. But I don't think your position is that judges are obliged to accept all that the police officer says unless it's contradicted.
I have no objection to the maxim, be careful what you wish for, Your Honor. But I believe that that's not what's operating in this case. Here, we have 2 central facts. There's uncontradicted testimony regarding them, and we know that the mechanism for disregarding them is faulty. And so that,
the mechanism being the inference of the missing witness.
Yes.
And if you put that aside and simply say he just did not credit it, and would that not be enough?
Our position is you can't simply say he just did not credit it to allow the judge to make an entirely subjective decision about credibility. He does, after all, write about credibility here. He gives us his reasons. He doesn't say A and B are true, but there's also a lot of other stuff when he's written on it. If I may, I'd like to move quickly to the question of...
but before you leave that point, I just want to go back to what you first said. Let's assume we accept all that you say. Let's assume we find that the judge was clearly erroneous and that indeed the defendant did ask for his family to be there and the courtroom was closed. In the absence of objection, in the presence of LaChance, you're still not going to win, are you?
Well, we believe that because this case is not final, we would adopt the reasoning of the dissenting justices in LaChance and to say that the right to a public trial should not, under those circumstances, be allowed to decay into a right without a remedy.
So you would need us to embrace the dissenting position in LaChance?
Well, we would need to have you apply it to a conviction that is not yet final, because this case is still pending on direct appeal. Okay. In terms of the prosecutor's closing argument, the prosecutor during the course of the closing argument refers to the defendant as a monster. In that closing argument, this is not one fleeting reference, it's 4 references, and it's not simply a matter of reference, it's a well-developed paragraph and theme which occurs and gets added strength from occurring towards the conclusion of the prosecutor's closing argument. The Commonwealth's position that this was somehow invited by the defense counsel saying that no one in this case is an angel, no one is a monster, does not entitle the prosecution to then argue someone is a monster. In this situation...
I thought the defense counsel was talking about the Commonwealth's witnesses who were family members or friends of the victim and saw him, and defense counsel was characterizing their testimony as presenting the defendant as a monster out of love for her or out of,
Yes,
loyalty to her.
What defense counsel does is to say, in essence, these witnesses say she's an angel, he's a monster, but these are human beings, no one's an angel and no one is a monster. Now, what that does not do is open the door to what amounts to bad character evidence, an argument that someone is a monster and therefore is predisposed to act as a monster. The way to open the door to bad character evidence, even if bad character evidence is permissible, is to put in good character evidence. That doesn't happen here. There's no effort by anyone to claim that Cadet has a predisposition to peacefulness and good order or to nonviolence or anything like that. The harm done here is not trivial. This is a situation where to use this predisposition argument of this person is a monster and could have been expected to act as a monster retroactively mobilizes a huge quantity of evidence regarding prior bad acts and asks the jury to use it for an improper purpose. There's a lot of litigation here about prior bad acts evidence. The judge allows all of it in for all intents and purposes, and that evidence is allowed in for a specific purpose, which is to reflect on the nature of the relationship. But this is not about the nature of the relationship. This is about the nature of the defendant. We argue that what should be applied here is the prejudicial error standard because counsel for the defendant did ask for a standing objection to the misuse of prior bad act evidence during the pretrial litigation of this issue. But even if the standard would be a substantial likelihood of a miscarriage of justice, we think this is an extremely destructive closing argument. There's no effective cautionary instruction used. Compare this to the Rosario case where the jury is instructed immediately to disregard completely the evidence, and you can see very clearly the difference. Here, what you have is the somewhat vague instruction that prior bad acts can come in only to show the nature of the relationship. That's no defense, it seems to me, against a juror saying the nature of this relationship is that it's a relationship in which one of the partners is a monster. And therefore could be expected to behave like a monster. To turn quickly to the jury instructions, we have here a case where we know the jurors did not return a verdict on deliberate premeditation. They're instructed, of course, that deliberate premeditation can be formed within a matter of seconds. What that would seem to indicate is that the jurors' focus is concentrated within a period of about 2 minutes, perhaps, immediately preceding the homicide and during the execution of the homicide. What we have then is an instruction in which the trial judge tells the jury that if the Commonwealth does prove excessive force in an effort to defend oneself, you would be justified in finding the defendant guilty of manslaughter. I would ask the court to compare that instruction with the current model instruction on excessive force in self-defense. And the flaws in it are quite evident at that point. But I would also ask the court to compare that instruction with the other instructions in this case on mitigating factors. The structure of the whole charge here does not save this instruction. It badly aggravates it. The structure of the charge is the judge, first of all, lists properly the 3 mitigating circumstances. He then treats sudden passion separately. He instructs on sudden passion. He says that if the Commonwealth does not disprove sudden passion, the Commonwealth has not proved malice. He does the same with sudden combat. At the end of that instruction, he says if the Commonwealth has not disproved sudden combat, then the Commonwealth has not proved malice. He then says, in summary, if the Commonwealth has not disproved these mitigating circumstances, then you cannot return a verdict of murder. He then moves seamlessly, without announcing that he is turning from mitigation to excuse, to a lengthy series of observations about the law of self-defense as an excuse. During that, he talks about many things that have to deal with proportionality. Talks about you can use no more force than necessary for self-defense. Tells them to consider the relative physical capacities. Tell them to look at reasonableness. At the end of that section, he then moves to the charge which I have just read. But after that charge, again, seamlessly, without announcing he is then returning to mitigation, he does not say that if the Commonwealth fails to disprove that the defendant acted in self-defense but with excessive force, the Commonwealth has not proved malice. And he does not say what the courts said in other similar cases like Glacken, that murder is unavailable. There's a broad highway left open here for a juror to find murder in these circumstances, even if that juror believed that what we have here is the use of excessive force in self-defense. And we believe that the juror's request for re-instruction on this is significant about that. We believe that the juror's failure to return a verdict on deliberate premeditation indicates that they were concentrating. The source of their confusion had something to do with the means, the manner, the proportionality, the excessiveness of the force used to perform the homicide, and therefore we think there's a substantial likelihood of a miscarriage of justice.
All right, thank you.
May it please the Court, Mary Lee for the Commonwealth. If I may, I'd like to begin with the jury instruction issue that my brother just left off on. I want to correct a misimpression that evidently came from my brief that the defendant puts in his reply brief at page 14. He suggests
14 of your brief or of his reply?
I think my brief's correct, and that the reply brief is incorrect.
Page 14 you're pointing us to is of his reply or of your?
His reply brief is page 14. He says that the quote that I use regarding that the instruction that's at issue has an ellipse of 59 pages, and that is not correct. My brief cites to pages 113 and 152. The instruction that I quote is given in full at both of those places. The ellipse there is the judge misspoke and started again when he started on the third sentence. So the sentence that we're talking about is, the Commonwealth has the burden of proving beyond a reasonable doubt the absence of self-defense. If the Commonwealth fails to prove beyond a reasonable doubt the absence of self-defense, your verdict must be not guilty with respect to the crimes of murder or voluntary manslaughter. If, however, the Commonwealth does prove excessive force in an effort to defend oneself, you would be justified in finding the defendant guilty of voluntary manslaughter. So you'll find that at the transcript 6. I call it transcript 6. There's actually two transcripts labeled number 5, but it's the one with the instructions. Transcript 6, page 113, that's in there in its entirety. And then at 151 to 152, you'll see that paragraph again in its entirety. So I was not separating that last line from the other two sentences. The judge said those things together. So the jury did hear that their verdict must be not guilty with respect to the crimes of murder or voluntary manslaughter if the Commonwealth fails to prove beyond a reasonable doubt the absence of self-defense. So that quote was said to be not error in both Bowling and Britt. The only difference from that language in Bowling is that it also had a defense of another issue in that case. But that language is the exact same in Bowling and Britt. It was found to be no error in both of those cases. It was given to this jury twice, and it was the last word the jury heard when they were re-instructed on this case. So I would suggest there's no error, certainly no substantial likelihood of miscarriage of justice, and this case is as distinguished from Santos as Bowling and Britt were. So I would ask this court to find no error here in this case as well.
I think this judge was the trial judge in Bowling, wasn't he? I think.
Oh, I don't know who the trial judge was in Bowling. It's Judge Gaziano. Mm. If there are questions on that issue, I'm happy to answer them, but if it pleases the court, I'd prefer to move to the closing argument and the reference to monster. The Commonwealth's position is that the prosecutor's reference to the word monster is a direct reference to the defendant's closing argument, and we would suggest that it's...
You say at the very best, your argument would be that it gave license. It hardly needed a response.
I think it didn't need a response under Nelson and Cassidy. I think that it was appropriate at least to reference that word so the jury knew what the prosecutor was talking about. To the extent that this court finds that it's closer to fire with fire than fair answer, I would suggest does not create a substantial likelihood of a miscarriage of justice. And you know, in candor to the court, the prosecutor did use it 4 times. 3 of those times were contained in the direct answer to that argument. You should believe these witnesses because they actually saw things. Some of them were corroborated by other evidence. This wasn't their misperception. And so 3 of those times were in direct response to this argument, as in Nelson and Cassidy. And then he uses a rhetorical flourish at the end and uses it again at the end. And so...
perhaps better to be focused on facts or stubborn things than on name-calling in general, although I do understand that the name was first used, but may have been overdone here.
And that's, you know, that's the question before the court. Is this overdone? And if it is overdone, does it create a substantial likelihood of a miscarriage of
Well, now, he
justice?
says there was an objection, and therefore it's a prejudicial error standard. Is he correct?
He's incorrect. There is no objection to the closing argument in this case. The defendant's objection was in the course of a motion in limine on prior bad acts in their admission, and that does not cover a claim of name-calling in the closing argument. If he had made an objection based on name-calling in the closing argument, it's likely the judge would have given a curative instruction, as in Rosario. Now, and obviously, you know, the Commonwealth is not saying it's okay to name-call. It is not okay to name-call. That is error. It is not okay to use the term monster. Rosario says that, and Rosario was in place at the time of this case. What the Commonwealth is saying is there is no substantial likelihood of a miscarriage of justice. And so I apologize to the court. I should have quoted Kozak in the case. That's the leading case on closing arguments and whether reversal is required. And so that's 399 Mass 514. I know this court is familiar with it. And at 518 to 19, this court goes through the analysis of when is reversal required. And so the first question is, did the defendant seasonably object to the argument? And the answer is no. And you'll see that in the transcript. There's no objection to the closing argument. There's no objection to name-calling or monster, which is distinct from should prior bad acts come in, which is the defendant's objection. And so under Cobb, the absence of an objection is largely determinative of the issue because it suggests the tone and manner of the argument was far less damaging in real life. And of course, the defendant's counsel knew he had used that term himself and knew this was an answer to his argument. So the first factor of analysis under Kozak goes in the Commonwealth's favor. The second is, was the claimed error limited to collateral issues, or did it go to the heart of the case? This issue revolved around the credibility of witnesses who observed prior bad acts, and I would suggest it's a collateral issue. All of those prior bad acts, every single time a prior bad act came in, Judge Gaziano instructed on the limiting instruction that this goes to the nature of closing arguments and is relative to the motive and intent. And further, that instruction was given in the final charge. And further, the prosecutor noted at page transcript 5154 that the prior bad acts were governed by that limiting instruction. So I would suggest this is a collateral issue and that the second factor in Kozak also goes in the Commonwealth's favor. The third factor in Kozak is, what did the judge tell the jury, generally or specifically, that may have mitigated the prosecutor's mistake? And generally, did the error in the circumstances possibly make a difference in the judge's conclusions? And I would suggest we don't have the boilerplate jury instructions in this case. We have very good jury instructions. We don't have Rosario because there's no objection.
Does that mean that the boilerplate are not very good?
I'm not saying that, no. Okay. I'm saying this is better than very good.
Better than very good, okay. Very good.
Here, as I said, the trial judge gave the proper instructions on prior bad acts. Prior to the closing arguments, before the jury heard the closing arguments, he said, The closing argument is the chance for each lawyer to foster the facts as they see it, to convince you to rule in their favor. But make no mistake about it, the attorneys are not themselves the source of evidence. The evidence comes from the witness stand, not from the mouths of the attorneys. He's in essence telling the jury, take these closing arguments with a grain of salt and with reference to the evidence. And then after closing arguments, he instructed them that their decision must be based on the cool, reflective, and impartial sifting of the evidence, unswayed by bias, likes, dislikes, emotion, sympathy, passion, or prejudice. The danger the defendant is foreseeing in this case is exactly what the judge is telling them not to do. This isn't about name-calling, and this isn't about who do you like and who you don't like. This is about the evidence.
Yeah. Can I just interrupt you here? I mean, my sense of this case is that the evidence about the relationship went in, right, to go to what issue? I mean, this was apparently a relationship where there was considerable domestic violence.
Yes.
And that was pertinent to...
The motive and intent. The defendant said that the victim had attacked him
And
with
so it
two
went to the
knives.
question of whether or not he acted in self-defense.
Yes. There's no question he is the person who killed Bettina Francois. He left a note at the scene saying that he'd had enough, and that she'd called him there, and that she threatened to destroy his life, and that he didn't. There was a restraining order at the time. If she had threatened to call the police,
Back and forth and back and forth and back and forth, notwithstanding the restraining orders.
if she called the police, though, he'd go to jail. There was a restraining order present at that time. She threatened to call the police. His note said, I don't believe I deserve to go to jail, and I view my life as over. So that's very strong evidence that, and in his testimony, he admitted he wrote that note. It did not have any reference to any attack by the victim in the note. So there's very strong evidence in this case as well, which also weighs in favor of the Commonwealth's claim that this instruction did not create a substantial likelihood of a miscarriage of justice.
He was also wounded?
He was. He claimed that she stabbed him.
And he had stab wounds.
He
like
did.
Serious wounds, didn't
In
he?
his throat and in his stomach, yes.
Yeah.
He did.
And so it's the Commonwealth's theory that those were self-inflicted?
Yes. And he has there's some of his blood is at the scene. It's on one of the knives. And there's some blood in the car, but not on, like, the shift. I just detail in my brief, like, not on the steering wheel, but on the headrest, et cetera. So, and then he is able to drive for, there's an hour and a half between the time she's killed and he crashes the car at 100 miles an hour in Exeter, Rhode Island. So somewhere in the nature of an hour and a half, hour and 15 minutes, somewhere in there. So it's very strong evidence that he is the person who did this crime. It's very strong evidence of motive. And the defendant was also able to put in the favorable past evidence that this was an on and off relationship. They lived together sometimes. They took all these trips together. She used his car when her car was damaged. She called him, he called her, he visited her office, he went to a work event with her. So it's not just a laundry list of prior bad acts of the defendant, it's also a laundry list of all the things they continued to do together despite their tumultuous relationship. And if I may move back to the judge's instructions, which is the third analysis in Kozik, after he told the jury not to be swayed by likes and dislikes and sympathy and passion, he then reminded the jury that closings are not evidence, and he said that the attorneys were not there. They do not know for themselves what went on. So I would suggest that these instructions are strong instructions both before and after the closing arguments. In the context of this case, though the word monster is not appropriate, it is error to use the word monster in the context of this case. It was invited. It was used first by the defendant. There's no objection. It goes to a collateral issue, and we have very good instructions from the trial judge. We would have had better instructions if there were an objection, just like in Rosario. And so in this context, I would ask this court to find no substantial likelihood of a miscarriage of justice on the Commonwealth's argument. The jury necessarily would have seen, particularly that last phrase, as a rhetorical flourish in reference to the defendant's closing argument. If there are any other questions on that issue, I'm happy to answer them. Other than that, I would move on to the next issue. The next issue I'd like to address is that the defendant, in his brief, claimed that without explanation, the defense counsel and the judge and prosecutor just excluded reference to conversations that went on when the defendant and the victim were having their final argument that resulted in the victim's death. And I would suggest to this court, as I did in my brief, that that's not an accurate assessment of the record. There was a motion in limine that the defendant won. And in that motion in limine, he was able to keep out substantial evidence that was very inculpatory towards the defendant and would be very harmful to his self-defense argument, specifically statements of the victim. And some of those statements of the victim entailed his prior threats that he would kill himself if she tried to leave him, and that he had done other things to her, including a rape and beating and a biting that had not been reported to the police. And having won that...
These were statements of a conversation she had with him?
With other people.
With other people.
She told other people about her conversations with him. And so the judge correctly ruled on the motion in limine, the defendant is correct. You can't get into those statements. He led in two things. I believe it was the restraining order, not the affidavit, and one other thing that, I'm sorry, escapes me. But for the most part, the defendant won that motion in limine, and some very damaging evidence was excluded. And the trial judge noted to defense counsel, but the case law means that you might open the door to it if you start bringing in other stuff. And the case law does do that. You see Sharp, Tassinari, and McGraw. And this is a self-defense case. McGraw has a self-defense issue that does let in some victim statements to contradict a self-defense issue. But even with that, the judge said, I'm keeping all that stuff out, but you might open the door, be careful. So during the Commonwealth case, the victim's brother-in-law started talking about one of these beatings, and there was an objection by counsel, and that got stricken. And so that is clearly his strategy. And then in the direct testimony of the defendant begins testifying, and there is an objection, and the judge sustains the objection, and counsel then begins couching all his questions to avoid that area that might open the door, i.e. the victim's statements. So I would suggest that this is not without explanation. This is a strategic decision. It is tactical. It is smart. It's part of the whole plan. The defendant has not presented an affidavit from counsel in his motion for a new trial to show that this was ineffective. This was the plan. Now, then I think this court must look under 33E, was this all okay? And I think you will arrive at the decision that it is okay, because the defendant at page 80 of the defendant's record appendix in paragraph 6, he details what he would have liked to present. And you'll see they're not even statements of the victim, as he's suggesting. He said he wanted to put in evidence that the victim instigated the fight that ended in her death. Well, he did testify to that. He said she came at him with 2 knives and wouldn't let him leave, and he was just trying to walk around her. And so you'll find that at transcript 5, 219, and 263. He said he wanted to present evidence that the victim was insane with rage when she attacked him. Well, that was presented, that he could not reason with her, as she's got these 2 knives saying, am I going to do it? And that was presented to the jury. And so you find that evidence at 216, 219, and 263, also of transcript 5. So then the last 2 things that he said he wanted to present, that the victim was angry because the defendant told the victim's family that she was raped by a cousin and was arrested for shoplifting. Now, the jury knew that the victim was angry with the defendant for his interactions with her family. That's at transcript 3, 197, and that's right around the area where there's this objection to the brother-in-law's testimony. Well, that's not the story at all that they're going to get from the brother-in-law. They're going to say that there was a beating. And you'll see that at transcript 3, 196 to 197, and they thought that the defendant was being disrespectful to the victim. That's the source of that controversy. So if the defendant puts in that statement, then the stuff that has just been excluded on day 3 is going to come in to rebut that. And it's clearly inconsistent with trial counsel's strategy. And then the 4th thing is that he wanted to present that the victim was jealous because the defendant had been cheating on her, which she discovered from her brother-in-law, and the defendant claims that this evidence was relevant under adjutant. Adjutant has nothing to do with this. There are no claims that the victim had specific acts of prior violent conduct. And so being a victim or a shoplifter or being jealous because your boyfriend's cheating on you, it is not adjutant evidence. But furthermore, I would suggest that this concern of claimed jealousy over dating would open to the door to testimony from the brother-in-law that the defendant had been abusive to Francois throughout their relationship, including that the defendant had raped the victim and had taken a knife numerous times, threatening to kill himself. That's the defendant's record, Appendix 32, showing his, his proffer in the motion in limine. And it might also have opened the door to the victim's statements that she planned to date another man, though the defendant would have been angry. And that's, you'll see at Defendant's Record Appendix 33. So most of what the defendant is saying he wanted to get in, he got in, that she started the fight, she came in him. The other collateral stuff that would paint her in a bad light would open the door to evidence that trial counsel was working at keeping out. So I would suggest this is not a substantial likelihood of a miscarriage of justice or error at all. The judge's decision on the motion in limine is in the Commonwealth's Record Appendix at page 6 to 13. It's also at transcript 2, 5 to 12. It was right on the record. I see my time is almost up. I'm happy to answer any questions. If there are no questions, then I would ask this court to affirm the defendant's conviction. Thank you very much.